Today, we're going to be talking about the different types of law or jurisprudence that dental hygiene practice falls under. A lot of the times, there's a lot of different law terms, and so this is just an overview, kind of a breakdown of describing different kinds of law and how they apply. By definition, jurisprudence is the science or philosophy of law that includes the establishment of our laws, how they're established, how they are made, the regulation of law, how they are regulated, and the enforcement of law, meaning who is our checks and balances and where does that enforcement come from? So for the first definition, we're going to talk about statutory law. Statutory law is specifically referring to statutes. Statutes are the actual laws that get written into law. These are enacted by our legislatures, and we have different levels of legislatures throughout the United States, right? So the first level can be through our local legislative bodies. This might be your municipal government, your town, your city. It could be your county. The next level is your state. So state legislatures also write state law, which you also have to follow. And then the very top level is our US law, and that is enacted by Congress, and those federal laws are enforced through the Supreme Court, essentially. All of those laws then are enforced through law enforcement. There's two types of statutory laws that you can break. The first level is criminal. These are crimes against society or the public or anybody really. You can't commit a crime, right? You can't harm somebody. You can't murder somebody. These are crimes against people. And I shouldn't even just be exclusionary with people. It can be animals, pets. It can be a range of different things, but committing a crime puts that act under criminal law. There's also civil law. Civil law is an act against somebody's person. So this can be their privacy, could be their property, their contractual rights if you enter into agreement with them. Basically, the person that you're violating against, violating a right, they are going to seek civil action against you, and that is under civil law. So again, just to review, statutory law can be broken down into two categories: criminal law and civil law. So let's talk about the specifics of criminal law. This is specifically designed to prevent harm to society. Basically, it's the government's way to protect us, right? We are members of your government. We know that within this protection of the government, that these things shouldn't happen to us. And if they do happen to us, something will be done to make it right. Typically, state or federal government takes action against the person that did you harm. State laws apply to everyone that comes to their state. Even if they're not citizens of the state, they still apply to people if you cross the border. And that's important because a lot of the times when we're traveling or maybe we're in another state for a long period of time, it's important to understand those state laws, because if you break a law in that state, doesn't matter if you're from Minnesota, if you come to South Dakota, these are our laws. Same thing with federal laws. Federal laws apply to everyone, right? That is national. It doesn't matter what state you're from. If you break a federal law, you are breaking a law in the US government. When these cases get decided, they go before a jury. And in these cases, the level of proof, right? You're innocent until proven guilty. And the level of proof is beyond a reasonable doubt. That means that it is unanimous, that all of the jury members agree that you are either guilty or innocent. They have to be absolutely convinced. And what's good is that you are innocent until proven guilty. That means the prosecutor or the person that is arguing towards you has to prove beyond a reasonable doubt that you did it. And this is important because there are some serious sentences. Some states still have capital punishment. And so very important in those cases, especially, I mean, this is life or death. It's very important to make sure that they are 100% certain that this person committed that crime. Civil law is a little bit different. Civil law means that you have violated somebody's rights. This can be them as a person. It could be, again, their property, as we discussed, or it could be a contract right. So if you enter in a contract and you don't fulfill the contract, then you are violating that person's rights. If you do that and they seek legal help, they will file a lawsuit against you. Basically, what the lawsuit is trying to do is to compensate you for something you were not given. This can be medical damages if you were in an accident and somebody hit you and it wasn't your fault. They would compensate you for your medical expenses. They would compensate you for your missed work. If it was a contract, for example, let's use dental hygiene. If you entered a contract or a treatment plan with somebody and you didn't complete the cleaning very well and they had to go seek care from somebody else, they would file a lawsuit against you in order to compensate them for the work that you didn't do, and then they had to get work done elsewhere. The main difference between civil law and criminal law is that civil law does not require the same amount of being sure. Civil laws require a preponderance of evidence, meaning 51% of the jury or the judge deciding over the case is 51% certain that that person is guilty of violating their right law. So what does that look in dental hygiene? So because we're healthcare providers, we as dental hygienists have specific statutes or regulatory items that fall under the State Practice Act. Again, we talked about this in the Licensure Practice Act lecture. I'm bringing it up again because this is another layer that we as healthcare providers have to follow under the statutes of our Practice Act. It's specifically important because if you get disciplined for violating the Practice Act, you would be disciplined through your state board. Disciplinary provisions can be varied. First, if you do something outside of your scope of practice or violate a patient's rights, typically a complaint will be made against you to the governing body. This can result in a number of different things, right? Your license could be suspended, your license could be restricted, meaning you can only do certain things, or your license can be completely revoked and they will tell you you are no longer allowed to practice dental hygiene in the state of wherever you are. Sometimes the lines get blurred a little bit, meaning if you break a state law or a state statute, you are required to report yourself. So for example, if you get a substance use or abuse charge, if you get a driving under the influence charge, DUI, because that's breaking a state law, you are required to report that to the board where you're practicing. This is important because they have to know if you have violated a state law, because that typically impacts your ability to get licensure. A lot of the times for the first offense, it's not going to result in revoking your license, but a lot of the times it will be that you may need to go to alcohol classes or you may need to go to some sort of detox in an effort to get your license back to its full use. The reasons that these are blurred is because a lot of the times, breaking a state law can also go against what the State Practice Act is saying. For example, if you're using substances inappropriately and you get caught, they want to make sure that you are not doing that while you're practicing, right? And so that would be related to the scope of practice because we have to make sure you're practicing to the standard and to the level. Other things that you can get in trouble for is really anything that is under state law. So again, unprofessional conduct. I'm just thinking like drunken disorderly or getting an altercation or a fight with someone can have a lot of repercussions on your professional reputation. And so if you get in trouble with the state under your State Practice Act in any area, in any realm of state law, you must report it because that may impact your license. And if you don't report it, it's going to be worse if they find out through court documents than it is if you would have come to the board first and reported yourself, and then they go through whatever disciplinary provisions they're going to ask of you in order to keep your license. Clinical incompetence is another one. You may get reported maybe by a coworker. Hopefully it doesn't come to that. When we talk about ethical dilemmas, we also talk about what would we do in that situation. And now clinical incompetence, if it's being reported, typically it's something that's happening a lot and it's not being addressed. But again, if you run into that situation out in practice, just know sometimes it is nice to address those things with the provider that you would be reporting versus just going straight directly to the board. A lot of the times people or providers may not know or understand maybe what they're doing wrong, and it's super helpful and it builds trust to address it that way. All right, more commonly, a lot of the times, especially in civil suits, we fall under common law or case law. That's different than statutory law because statutory law has something to do with a law that is written down and voted on through Congress. Case law is a little bit different. Case law is the examples of when you hear like a Supreme Court decision and they're referencing a precedent. A precedent is a case that has happened in the past that they are using to set a precedent and then make future decisions on similar cases based on what they decided in a precedent case. A lot of the times, because they're usually hotly debated cases or important cases, these typically make it up to the Supreme Court level, but not always. And so it says here it's formulated by judges and or court decisions because they can use any decision to show a precedent. Based on the judgment in that case, they typically make a decision to side on however that precedent was set. And this is typically the type of law that healthcare providers seem to find themselves in. And a lot of the times it does end up being some sort of civil suit. It doesn't mean that you necessarily broke a state law that's written down, voted on. It means that in a precedented case, this is something that has been done and this is what they did then. So many laws related to healthcare come from case decisions or common law. Next, we're going to talk about tort law. Tort law is also a little bit different, but very similar. I think you'll see a lot of similar themes, but they're just referred to as different things. And there's a lot of overlap. That's why I thought this video was important to do because there is overlap, it just helps kind of understand the different terms. So tort law is a civil wrong that results from a breach of duty. That duty exists from society's obligations and not a contractual obligation. So it could still result in a lawsuit, but it's from a lawsuit that is a societal expectation, not necessarily a written down law. Now, some of them do overlap, and we'll kind of talk about those when we get to them. An intentional tort is an act done intentionally, and that's really key. When we talk about the findings of these cases, they have to prove that it was done intentionally. Now, sometimes there can be some gray area, but it's important that you as a provider protect yourself, which is why it's important to kind of understand the differences here. Intentional is specifically deliberate or purposeful, meaning it's an action that you're doing, not necessarily an omission, unless you omit something on purpose. Intentional also means that there's an intent to harm. There's an intent on physical or mental harm to an individual or their property. Unintentional then is completely the opposite. A lot of the times this is neglectful behavior that results in a negative outcome. Again, intent is the key here. There's not necessarily an intent to create harm, but harm is done unintentionally by not doing something or omitting something. So we're going to look at a couple different examples of an intentional tort specifically in dentistry. First is assault. The definition of assault is any action that produces fear of bodily harm or threatening to harm somebody. In dentistry, this is blurry, right? There does not have to be physical touch in order to be assault. And let's look at the next one before we look at examples. The next one is battery. Battery is very similar to assault, but this is with the physical touching. This is intentional infliction of harmful or offensive bodily contact, so actually touching someone, or non-consensual contact that is damaging to reasonable dignity. Basically, you're touching someone with the intent to harm. So the differences here are that threats can be considered assault, and that's the key thing to remember. Even if you don't actually touch someone, if you are having a verbal altercation with someone and threatening them to beat them up or touch them in some sort of way, that can be an assault. Battery can be touching. The key important thing I think to remember here is the non-consensual contact. In dentistry, a lot of the times we deal with minor children that have parents that may or may not be in the office. And I think assault is less likely, but battery can be maybe a little bit more likely to be brought forward, especially if you're dealing with a minor and a parent that is upset with what you did. If you didn't obtain informed consent from the guardian or the parent and you do a procedure on a child and their parent is upset, that is grounds for battery because it's non-consensual contact that they may deem as damaging. Let's use sealants for an example. If you have a prophy and you see, oh, their 6-year molars are in, let's seal them up. And that parent, maybe it's a custody thing where, two different parents, and one of the parents is very against sealants, kind of like the fluoride thing, right? They're very against sealants, don't want sealants, and they find out you did sealants. To them, that is intentional harm, or it's contact that is damaging because the outcome isn't what they wanted. That would be an extreme example of battery in dental hygiene. And that's why I have it down below. A lot of the times, if these cases make it to court, they call it technical battery. It's not as egregious as normal battery as we think of, like getting in a fight and assaulting someone or punching someone. But it's technical battery because it's using the technical terms of non-consensual contact in order to create a case. Defamation is also something that is intentional, right? If you're intentionally writing something or verbally saying things that are bad or negative about another provider, that would be an intentional tort. You're intentionally causing harm to somebody based on the words that you're saying. Libel is written. So again, I'm thinking notes, right? You write a note about an office down the road, that chart note gets subpoenaed in a court case, and there's documentation. That would be libel. Slander is something that you're saying. So if somebody overhears you talking bad about another office when you're out to eat, and they hear you and they report you, that would be slander. That's verbal. Next is an unintentional tort. These are things that we do not intend to harm with, but end up harming somebody based on either something we did or didn't do. A lot of the times this is neglect. Many cases, this comes out as neglect. So what is neglect? Negligence is the failure to act as a reasonable, prudent person under a similar circumstance. And I've given this example a few times, but if you were brought to the state board of something that you did in a dental hygiene setting, they are going to look to the standard of care and other dental hygienists to say, what would you have done? And this is where it's really important that you're practicing to standards, because if you are, and they all say, yes, I would have done the same thing, you are way more likely to get out of that case. Failure to perform to the clinical standards is the most that we can harm a patient, right? Using old techniques that no longer work, doing SRP until you're removing that cementum. Those are old things. And so if we're still doing those, knowing just because we may not know that that's the standard, it still doesn't make it right. Now, it's important to remember though, a mistake without harm isn't negligence. And hopefully you can just take a breath of fresh air and be confident in that. It's okay to make mistakes. It's okay to not have the up and coming technology of every brand new thing. I don't think that's what we're saying here. What we're saying is that we practice to standards and maintain our CE. We really should have nothing to worry about. I think there are a lot of checks and balances. I think our coworkers keep us in check. I think our state board, the way that they audit and maintain our history, all of those things are checks and balances. It's not just a pain in the butt thing that we have to do every year. It is a way to ensure that you are maintaining the standard of care and that harm is not done. That kind of all falls under the standard practice, but this could be something super simple as well. This could be something not dental hygiene related, but for example, it's super snowy here in South Dakota and we have ice on our sidewalk. Now we have a patient that comes up the sidewalk, and because we didn't put out salt, now they've slipped and fell. We've created a dangerous environment for them. Or we mopped and we didn't put up a wet floor sign, so now they fell in their bathroom and they hit the head. Those are all just kind of silly examples, but all of those are examples where negligence could be brought against you or the office for not creating a safe environment, and because you were neglecting the environment, then the patient received harm because of what you did or didn't do. So hopefully that review was kind of helpful in understanding criminal law, civil law, unintentional tort law, and intentional tort law. So now that we understand all of those different definitions of law, what do we do about it? What is your role as a hygienist? Very similar to previous lectures, they are all similar, right? We have to understand what the laws in our state are. So once we understand those laws and understand kind of through the scope of practice, what we're allowed to do, what we're not allowed to do, we have to document everything. The more you document, the more you are creating a case for yourself in defense. I know this feels a little bit like the sky is falling, almost like fear, right? And I don't want you to be fearful, but I want you to be prepared and I want you to be thorough in the way that you protect yourself. If you protect yourself from day one when you get your license and you protect yourself throughout, any time that any of these silly things could be reported against you, you have protection. And not only does it maintain societal trust, but it also helps maintain your license. Your license is the most valuable thing that you have. You bought a college degree, you took all the tests, you passed your jurisprudence exam, and now you have a license. That license is your livelihood. That license is your ability to make money. That license is your career. And you should protect that license like it is as valuable as it is, right? If you calculate and think about the money that you will make based on that license, that's how you should protect it. You are protecting it through professional liability insurance. Again, very affordable. It's almost like disability insurance for missing work, right? You're protecting that license. And so that license is just like this little gold trinket thing, and you cannot lose it. So protect it, please. I hope that helps understand law. Thank you for listening. If you like this content, please share, like, subscribe, and I will see you on the next one.